Welcome back to our continuing podcast series on the effect of the COVID-19 pandemic on the criminal courts in Ontario. And today I'm joined by our office manager who manages very capably, I might add, our Kruse Law firm. Welcome back to the podcast, Jody.
Thanks so much, Mike. Glad to be here. So what are we talking about today, Mike?
We're going to talk about COVID-19 impact on trial delay in the Ontario criminal courts.
Oh, good topic. So, Mike, what exactly to our potential and current clients or anyone else that might be interested in this information, what exactly is Jordan trial delay? What can you define that for us?
Yeah, for sure. Well, first of all, Jordan is a case from the Supreme Court of Canada that sets out the guidelines for how quickly you should get a trial in Ontario.
Okay.
And under the Section 11B of the Canadian Charter of Rights and Freedoms, Jody, everyone has a right to a trial within a reasonable time. And how do you define that? Well, Jordan, we started with cases in the 90s that define that called ASCOV. And Jordan finally came up with very stringent guidelines and clear guidelines, thankfully, because it was very uncertain for many years. So Jordan says this: if you're arrested today and you have a charge and you decide to be tried in the Ontario Court of Justice, that's the lower courts. And the Ontario Court of Justice does minor cases and serious cases. They can do very serious cases too. From the date of your arrest till the date your trial is completed should be 18 months. That's a very strict guideline, unless the defense caused certain periods of delay.
Unless the delay is caused by defense.
Right. Now, for the Superior Court of Justice, that's for our more serious cases like murder and sexual assault and aggravated assault cases. The delay there, it from the date of arrest till the date your trial is completed, has to be 30 months. Now, if your trial is not completed in these time periods, you can bring an application for trial delay under Section 11B of the Charter. And if the judge agrees that the timelines have not been followed, and it's a very involved application, it's a day or two or three in court sometimes arguing this with transcripts, with factums, they would stay the charge, which is effectively the charge is gone. Okay.
Similar to a withdrawal?
Yes, it's very similar to withdrawal. In that context, the case is never going to be revived. You haven't been found not guilty, but your case is over.
Okay.
So that's the definition of Jordan trial delay.
So that's very interesting. So with anyone during the pandemic that wants to, or let's start with wants to set a trial date, are those dates right now at this stage of the pandemic, even when we were back in the summer or spring months of pandemic, we already know in the spring of the pandemic that they were not really scheduling anything because courts didn't even resume until July 6th, right, Mike?
That's exactly it. Now, what was going on in the summer is our Ontario Court of Justice and our Superior Court of Justice in Ontario, as of about mid-March, all trials were paused. There was no trial. So we had hundreds and hundreds, if not thousands of trials scheduled from March till July 6th. None of those cases took place. So they all got adjourned or put on pause effectively. On July 6th, they opened a limited number of courtrooms in the province. Now, bear in mind, there's hundreds and hundreds of courtrooms in the province.
Very limited.
There's 52 Superior Court justice locations across all of Ontario, including Northern Ontario. Now, bear in mind, on July 6th, they opened, if I recall correctly, only 93 Ontario Court of Justice courtrooms. And you can imagine in big cities, there's dozens of courtrooms. And they opened up, I believe, 53 Superior Court courtrooms. Now, that was a limited number. They're continuing to renovate. So what did this cause, Jody?
Huge backlog, Mike, with trials. Some people were waiting already at that point, a year, 2 years for their trial that was just around the corner before COVID hit. So how fair is that to someone? What's going to happen now? What are the Crowns doing, the Crown attorneys? Are they taking any special stance with those people that have had their their case outstanding and set for trial, let's say, for, so long, and still really it's just been going over and over. They still haven't even rescheduled that trial date that was adjourned during the pandemic months as soon as it started. So what are the Crown attorneys doing or forcing? What is the pandemic forcing the Crown attorneys to do with regard to these trials that have been set and the trials that need to be reset? Is it forcing them, Mike, to relook closer at their cases and looking at potential more problems with the cases, witness problems or whatever, to tell themselves in their brain, is there a chance that I could, give these accused and their defense lawyers a better deal? Do I have a prospect of conviction even? Because at this stage, there may be problems with witnesses not wanting to attend court during a pandemic. They're prime witnesses in a defendable case that, someone's bringing to trial. These witnesses, do you really want to go out there, even though they claim and the courts are safe? Do they want to even be going and testifying? So these are questions I do believe the Crown has to address themselves with, and are they doing it?
Well, I'll tell you, it's been a huge problem for the Ministry Attorney General, a huge problem for our prosecutors to prosecute crimes. They are trying to come to grips with it for sure, Jody. And you can imagine someone languishing in jail. They're waiting. They're presumed innocent. They've been waiting for a jury trial, first-degree murder charge, which they're presumed innocent on. And some people are in fact innocent. We've seen miscarriage of justice. Their trial was put on hold. God knows when it's getting reset. They're resetting them now, by the way. We're refurbishing more courtrooms. But this delay kept building up. The Ministry Attorney General was panicky. I can understand it. Everyone was panicky in the system.
Yeah, what do we do?
Defense counsel. So what they've done a number of things. Now, first of all, you have to realize that we need to prioritize serious crime. Like, we can't have a first-degree murder charge or a serious rape charge, aggravated assault, break and enter, these serious charges. We can't have them thrown out for delay. We can't have a more minor charge tying up court time so that the cascading delay, so those other cases get bumped down the road. So the Crown's, what they did was they said, look, we've got to take a hard look at all of our cases. And we have to first and foremost ask ourselves, and they should be doing this all the time. I can tell you this, politically, they don't necessarily do this during normal times. And I think they might going forward when COVID ends.
They probably should.
They need to ask themselves this question. Here's the test. Is there a reasonable prospect of conviction?
Yes.
Number one. That's the question. That's the test for whether prosecution can continue. Now, politically, it's much easier for a Crown to look at their case and they say to themselves, look, I'm not going to win this case, but I don't want to deal with the victim. The case is just going to go forward. Let's tie up a week of court time. I know I'm going to lose. Do you think that's a good idea?
That's just a terrible idea.
No. So they are coming to grips with those cases and choosing to either pull those cases, withdraw them, or offer a deal that the defense counsel can't refuse. And that's proper. Those cases shouldn't be tried during good times, but if you look at it this way, if I've got an inexperienced prosecutor who's not been beat up in court enough. By the way, I started out as a prosecutor. I got beat up for a couple of years before I started understanding what cases should proceed and not proceed.
I would have liked
30
to
years
see
ago.
that.
I've been beat up less since, hopefully. I'm trying to learn my lessons over the years. But, it's difficult for an inexperienced prosecutor to come to grips with these. So they're learning quickly. Senior Crowns are looking at files carefully, deciding which ones are proceeding, deciding which ones we should offer a lenient deal on. So they want to avoid this delay. They want to avoid hundreds, if not thousands, of cases getting thrown out. So they're doing two things. They're offering some degree of leniency on all cases within reason. I shouldn't say all cases, because on more serious cases, it's hard to offer leniency. But if there's a way to shift a case down from, say, 5 years to 4 years, which is palatable for everyone, the judge, the defense, they're doing that. On more minor cases, we're seeing great deals because of COVID. I'm talking about DUI cases, mischief, driving offenses, lower level property crimes. If there's a choice between jail, which is it's a gray area on a good day where you could go to jail or not, we're avoiding jail. We're avoiding records on certain things. So this
So it's a good time to get yourself a lawyer.
Absolutely. And you know what? We don't truly know whether cases are going to get thrown out. I'll tell you, if they don't keep doing what they're doing, there'll be huge
Yeah, there's
delay
going to be
problems.
huge problems if they don't start, if they don't continue on the path that they're on now and kind of refocusing themselves on all of the files and getting, their things organized and taking a different path that they've been told to take. The system pandemic or not, there's going to be huge problems, huge applications for delays, which will then just have a stay of proceedings rather than even them getting a slight conviction on something minor that they could have done if they took a closer look at their case and their caseloads.
Absolutely. And what's going on in the Crown's minds right now is they're looking at these hundreds and hundreds, if not thousands of cases that got put over, and they're going, oh my God, I've got to deal with this. I've got new cases coming in every day. How do we deal with this? Trials are getting set, but there's only so many courtrooms renovated.
Yes.
What do? I've got to offer some degree of leniency where I can, which is still fair. I'm not giving away the farm. I'm dealing with it appropriately. I've got to come to grips with cases that I should have anyway come to grips and not proceeded and tied up, wasted court time. I can't tell you the number of trials I've done over the years where, as a defense counsel, I knew I was going to win. Why is the Crown Attorney running this case, tying up 3 weeks of court time?
Good point. Yeah, I remember there was a case we had, and it was set for jury trial. The case went on for almost 2 years, and the night before the jury trial, the Crown emailed and said they obviously got the complainant back in and decided there was no reasonable prospect of conviction after 2 years of waiting and 2 years of proceedings up until the night before jury selection.
And what was the net effect of that? You've tied up a courtroom for 3 weeks. It can't be filled. It's too late to fill another trial in there. One whole courtroom and a jury tied up. I've got a confession to make. I was a young Crown Attorney. I started here in Windsor and worked in Toronto for a year as well, for 4 years. During the first 2 years of your career, you really don't know what the heck you're doing. You're okay. You're getting mentored.
Just the first 2 years?
Hopefully. I shouldn't say you don't know what you're doing, but you don't have the experience to really call
Or is
cases.
that last week?
You don't really have the experience at that stage of your career as a Crown
agreed.
to know what can win and not. You need to get beat up. And I can remember many times during that 2 years, and this was pervasive in our system too, even for experienced Crowns. Look, we know we're going to lose. Let's just run it. I don't want to deal with the.
I think in their mind they think it's a practice run for them, but really they were dealing with someone's life here.
Yeah. That was the thing in the Crown's office. We said, let's just run it. I know I'm going to lose. Well, why do I want to run it, even when I know I'm going to lose? Well, number one, maybe I wasn't experienced enough to be able to make the call because I hadn't been beat up enough and didn't have the experience. Or number two, it became pervasive in this way, even with senior Crowns. Look, I don't want to deal with a victim screaming at me saying we're going to pull your case.
For sure. That's a nightmare.
Politically, it's a very difficult thing. Sometimes it's either just run it. Sometimes even during COVID, it's either run it on those cases. But I will tell you, the Crowns are coming to better grips with this. I think they're to be commended for it.
The Crowns get an A+, but they were also given a directive to do that. So let's not give too much credit to our fellow colleague, the Crowns, even though we love them.
Absolutely. I get along. Our office
We
gets
have
along
some
great.
wonderful Crown attorneys. So
Yes.
So Mike, let me just ask you with regard to this topic of trial delays and whatnot. If an accused has a case, Mike, and we've reviewed it or another lawyer's reviewed it or whatever the case may be, and it's not that defendable. So let's say we review the disclosure and we go, it's a weak case for us, it's our recommendation. Let's see, if we can negotiate the best outcome for you. But would another alternative for that accused be, Mike, is to go ahead and because of the better deals we're being able to get, because of the backlog, and of course, perhaps that person has higher risk of aftermath if they got convicted, getting deported, losing their job or whatever the case. So, why not set it down for trial? And that is one of, the newer cases that would be getting set. So they have, of course, to deal with all the ones before that. So I guess my bottom line question here is, if you do not have a defendable case and you have the money to pay a lawyer to set the trial for you, why not just set it for trial and then hope to get, wait it out and see if the Crown at a later date closes trial and dealing with the backlogs in the court case system, we'll go, oh, you know what? Here's another one we have to get off the shelf. Let's take a closer look, and maybe we can give this guy a better deal than when we started out. So I guess what I'm asking is your advice to certain people that have been given that recommendation to not take it to trial, wait it out. Set it for trial, wait it out, see what happens, see if we're given a better deal. I mean, at the end of the day, is it going to be any worse than if you didn't, if you pled out early?
What a controversial topic and a loaded question that is for defense counsel that I prefer not to answer. That's a good one, Jody. And I'll tell you, this is the way I would answer that. In all my years of practice, I know there are criminal defense lawyers who play the delay game, so to speak. They'll say, hey, why don't we just set up a trial, see if delay happens? There's no defense.
For many reasons, there's certain.
Now, I've never been a defense counsel to play that game or give that advice. There are situations where a client has asked me, can we do that? What if, this and that? And those are their clear instructions to me. And they ask for my advice of that. And I would say to them this, look, yes, we don't know if delay is going to emerge in COVID.
We don't really like to play that game. And you explain all that.
Yeah, but they give me clear instructions. What is your legal advice in this situation, Mr. Kruse? Well, my legal advice is this. Yes, delay we don't know if delay is going to emerge, number one. There's a perception that it could emerge, and you've told me that you've got a wonderful job. If you go to jail for 3 years, you're going to lose your entire career. If you're asking me if push comes to shove, whether you have a reasonable chance of getting your case thrown out due to COVID, it's hard to say. Better than normal times, and if you give me instructions to set it, I will. I can tell you this, though, and believe me, I'm not saying we're most... I'm not making myself any more ethical than I've never played that game other than taking the instructions, but saying I'm not advising you to do that. That's your decision. We'll do it, and we'll do it. So I've rarely set cases down for trial in my career that we had no chance of winning, if I might put that. Because I want to give people advice. Look, here's your trial. Here are the issues. I think you've got a 50% chance of winning based on ABC. Well, that's a case you should go to trial on.
For sure.
I think you got, this is a tough case, and a 50% chance, I would always recommend the person go to trial, 50%. Below 50, what is the offer the Crown's giving us, the risk, avoid...
What, is it going to be after we set a trial date?
Versus after trial.
Right.
Our odds of winning are only 15 to 20%. I leave it up to the client. Does 3 months in jail bother you versus one more after trial, one now, 3 then? So these are all things the defense counsel do. But if you're asking me if I tell a client ever to play the delay game, I wouldn't just volunteer that intent. I'm going to tell them that delay may happen in COVID.
And certainly no guarantee.
Yeah, I'm going to tell them as part of my advice, but they're going to have to be the person. Well, they're always the person that makes the decision to head for trial, but I'm not going to specifically say, hey, let's play the delay game here. Because what if every defense counsel in Ontario gets together and sets everything for trial? We'll cripple this system.
Well, that's one thing I will say here at Kruse Law. We are very honest about our opinions with the files, which, we take great pride in. We will be very honest in our opinion on as to whether we think you should take it to trial or whether a lot of clients go, what would you do? What if it was you? And we put ourselves in that situation and weigh out the pros and cons with them. So all very great information here, Mike, regarding the delay in trial situations during the pandemic.
It's going to be really interesting. As a member of the public, I hope delay does not occur. I guess I wear two hats, Jody. I'm a defense counsel. I'm here to protect persons' rights. If a delay on a particular case does occur, I have an ethical duty to bring the application to stay that. But as a member of the public, I'm hoping we don't want the collapse of the criminal justice system.
Yeah, that just delays things even further because now we need another date for the delay application on top of everything.
And getting back to your question about setting dates, I do think defense counsel has an ethical responsibility not to
We don't want to clog up
play
the system, yeah.
games and clog the system. What if every defense counsel we all get on a conference call tomorrow morning and says, let's set everything for trial and collapse the system?
Well,
It's
these
crazy.
are just some of the questions, obviously Mike being, one of the first people to speak to people when they call, like these are valid questions that some of the potential and even our current clients have asked that. So interesting facts. And hopefully the system will get better and hopefully some of the delay will die down as we find better ways and the court system finds better ways to kind of flow through the system.
Well, I'll tell you, Jody, and final word on this is number one, I think the Crowns are doing a commendable job. The Ministry Attorney General is doing a great job. They're exercising leniency where it's appropriate, not giving away the farm. Number two, they're assessing their cases better, whether they should proceed, and exercising leniency within there too. And number three, you're laughing at me.
We're going to do a separate podcast just to thank all of our government people in the ministry and the Crown Attorney's Office and court workers and everything else. And that's a different podcast, which we will give them true thankfulness and patience. But not on this one.
Yeah, I don't mean
we
to
don't want to pump them up too much.
I don't want to pump the tires too much of the Crown and Ministry Attorney General because I'm going to have a few critiques for them that they need to work on in some of the podcasts, including, let me give a little tidbit, disclosure is a problem right now during COVID.
This is a teaser topic.
Teaser.
We will be talking about disclosure, AKA police reports after someone is arrested and that we request when someone hires us. And I'll leave it at that, and we'll talk about that later.
Yeah, COVID is causing a little bit of a delay in that with the new system. So, Jody, it's always great to chat with you, our office manager. We're having a...
Thanks so much, Mike.
Yeah, appreciate it. And to all our viewers out there, I look forward to you on future podcasts. This has been a great chatting with you today, and I look forward to the future. I really hope you enjoyed our podcast. We are absolutely committed to bringing you informative and interesting criminal and DUI content. If you're watching this on YouTube, I ask and encourage you to like this video and subscribe to our channel. If you happen to be an audio listener, please follow us and stay tuned for more great content. If you've been charged with a criminal offense or a DUI in Ontario, please call us or reach out to us online with the contact form found at kruselaw.ca.